Welcome to CN Live, Season 2, Episode 16, Extradition, Extra Edition. I'm Joe Loria, Editor-in-Chief of Consortium News.
And I'm Elizabeth Voss.
Today's guests are Daniel Ellsberg and John Pilger. Week 2 of the resumed extradition hearing of WikiLeaks publisher Julian Assange has ended at Old Bailey, with a strong case having been made by the defense against sending him to stand trial in Virginia on espionage and computer conspiracy charges. Despite a succession of defense witnesses that undercut the prosecution's argument, it doesn't seem wise to conclude that Assange's team is winning the case. While Magistrate Vanessa Barrecha seems to be more even-handed as the hearing progresses, one can still not shake the impression that the case has already been decided against Assange. There have been some bizarre moments in this hearing. A coronavirus scare shut it down for a day and a half. Prosecutor James Lewis accused the judge of guillotining him with her time limits. The intrusion of a US TV report on Assange emanating from the computer of witness Eric Lewis, it turned out, cleared the courtroom. But there has been a lot of substance, especially in the past week. We learned that the US government says a journalist is not precluded from prosecution under the Espionage Act. This was a key change in the government strategy. It had previously said Assange is not a journalist, and they appealed to the press, the government did, that they were not the target of this case. The government has been zeroing in instead on Assange's alleged cavalier attitude towards releasing the names of informants, despite testimony from a parade of defense witnesses, some who worked closely with Assange, that he took every precaution to redact the names of these informants. A key moment this week was the testimony on Wednesday of Daniel Ellsberg, the Pentagon Papers whistleblower, who refuted that any informants have been harmed by WikiLeaks releases. He accused the government of cynicism and feigning concern for the informants when they refused Assange's requests for help in redacting them. Ellsberg also made a key point about how far the US has fallen in trying to hide its assassination and torture programs. You've said numerous times that the US does not have an official secrets act because of the First Amendment. I think the US should not have one because of free speech protections.
At all. But there's no question that the language of that not only covers journalists in principle, impossible, it's anybody who has who holds and retains that information unauthorized and or gives it to an unauthorized person. That doesn't apply just to journalists as well as officials who might give the information. It applies to readers just as well. If someone reads in the paper, the New York Times, we're withholding the identity of this person who gave us this because this information is classified. Once they've been warned that it's classified, if they were to show that newspaper to their spouse or fail, quote, in the words of the act, to give it to an authorized person, they're as guilty as anyone under it. So the overbreadth, the broadness of this is obviously an offense against the First Amendment. It's in line with the Official Secrets Act and of Britain. But the Official Secrets Act of Britain, I believe in 1971 or earlier, would almost certainly have been judged unconstitutional by the Supreme Court if it ever addressed that. In fact, our First Amendment is a major way that distinguishes our polity, our form of government, from that of Britain, Imperial Britain. The idea, one of the major things was to oppose the idea that criticizing the government is a form of sedition, even treason. They wanted to get away from that and limited the notion of treason in the Constitution, so it couldn't be broadened except by constitutional amendment. However, that wording has always been there, and for 50 years now, 49 to be exact, since 71, I've been warning journalists that they should acquaint themselves with the law and the constitutional aspects of this in preparation for having it used against them, but more importantly, to wage a campaign to change that in Congress, through educating the public and so forth. They haven't done it because up until now, the act has only been used against official whistleblowers, people who are either currently officials or had, like me, been earlier officials with a clearance and who were violating their promise to keep that secrets when they came to realize that holding that promise, carrying it out, meant condemning innocent lives or endangering the Constitution. So all of these most of the earlier whistleblowers who've been tried under this were patriots who felt that their country should do better and be better. And however, because the Espionage Act was not written to get whistleblowers, it was written for spies who give information secretly to a foreign government, especially in times of war. That's not one where the motives of the leaker, the spy, bear up very much in extenuating circumstances for a jury. So the law is a strict liability law written that you can't talk about motive or reasons for doing something at all. That makes it entirely unjust and inappropriate to use against whistleblowers if any law should exist. But if there probably could be written a law for leaking classified information that would pass constitutional muster for a reasonable or even liberal justice of the Supreme Court. The Espionage Act is not such a law. They can't be tried justly under this. And it would have to be changed or rescinded in order to have a law that would be fair in terms of the First Amendment. What's happening here now, and I don't think the press has recognized this, is that this is a direct assault on the First Amendment in applying it to a journalist or a publisher. I don't understand the reasoning or the motives of the journalists who have said Julian Assange is not one of us. He's not a journalist. I don't know why they're saying that, what they gain by this foolish statement, since he obviously is performing functions of journalism, presenting free, relevant, truthful information to the American public, which is what they do at their best. But in any case, it's very clear that if he is extradited and prosecuted under these terms and under the Espionage Act, by the way, as it stands, he would be convicted and probably subject to a very large portion of the 175 years he is facing. I faced only 115 years, so things have gotten even worse in that respect. But in this case, now there's no question, it would be a British Official Secrets Act. It should be unconstitutional, I would say, but it would mean that no journalist in the US who uses classified information, which happens every day or every other day, would be free of prosecution for life. And more than that, if Julian Assange, a non-American, a foreigner, Australian citizen, and now also Ecuadorian citizen, can be extradited for prosecution under these charges, no journalist in the world is safe from life in prison in the United States. So the very possibility of democracy or a move toward democracy, which depends on a free press, on an independent press, when they ask whether this is a political prosecution, I would say that what's at stake here is the very foundation of politics in this country, the question of what kind of government we want, whether we want an autocracy, a dictatorship, or a republic. That's a political question, I would say. And to hack away at the First Amendment, as this does, is the most ultimate form of political prosecution here, to basically aimed at changing our form of government.
It's hard to over-exaggerate what you're saying. It's absolutely an historic situation that is determining what kind of system we're going to live under. The unitary executive is one that Bill Barr has pushed that goes back to Cheney as well. And that is what I think you're describing. John, I'd like to move to you before Elizabeth and Alexander begin asking questions. You've been in the courtroom. Tell us about the treatment of Julian Assange, what you've seen.
Well, I've never seen anything like it. And I've reported from a number of courtrooms all over the world, and not all that long ago, I actually looked through some archive footage of the Stalinist show trials. I'm not saying there is a direct equivalence, we're in different eras, but there's something very similar about the sense of them. The difference is, I noticed in the Stalinist show trials, the so-called defendant actually stands freely. He will be in the dock, but he does have his so-called lawyers nearby him. That's denied to Julian. In the court that he's in at the Old Bailey, Court 10, right at the top of the old building. It's a modern court. Julian is confined in a corridor in which he couldn't really turn that easily. He can just turn around. But for Julian to talk to his lawyer, which is normal practice in any normal court, he must get down on his knees in front of this glass wall that's in front of him and try and make a sign to the people whose backs are to him. So all the court, except for the judge, have their backs to him. He's mostly successful in doing that because one of his legal teams is forever doing this to ensure that Julian makes contact with them. But he can't really discuss with his barrister his concerns because the barrister's right at the front of the court, so he must send notes up to him. He can send it through a chain of about 4 people. But again, this contortion that he must speak into this slit in the glass, the lawyer or whoever happens to be taking the message is like that against the glass. And so the messages are passed usually on post-its all the way to the barristers who are arguing his case at the front. This is a terrible, extraordinary spectacle to see this happen every day. But his day, it's all part of his day. His day starts at 5 o'clock. He's woken in his cell where he's solitarily confined at Belmarsh Maximum Security Prison. He is stripped naked, strip searched, x-rayed with, I'm told, a portable x-ray machine. He is shackled. He is presumably allowed to shower before he dresses, and at some point he must have some form of prison breakfast. But he goes through at least 3 checks, as draconian as this, before he gets into what his partner, Stella Morris, has described as a sort of tall, coffin-like. It's I think you described it, Joe, as a refrigerator. It looks like a large refrigerator being delivered. And in that is Julian. It takes at least an hour and a half, sometimes longer, through the worst traffic in London, from way down in the south of London to the Old Bailey. So that's at least 3 hours a day he spends in what is basically a windowless box. There is a window, but to reach it and to look out, he has to stand up while it's in motion. And he arrives at the court in what condition? I don't know. I'm always astonished whenever I've seen Julian in Belmarsh Prison, and as long as I've known him, astonished at the man's resilience to be able to carry on through this physical and mental ordeal. And so once in court, he's then imprisoned in this glass. It's not exactly a cage, it's a glass corridor. That's his day, but as I understand, he compares it with what his days have been, and that is solitary confinement for many, many months, without a laptop, without any intellectual stimulation, being imprisoned next to people with very serious mental problems. For a long time, he was in a cell next to a man who screamed through the night. And in the midst of this, when I last saw him, his black sense of humor was actually still intact. That he talked about it being one flew over the cuckoo's nest, and described these terrible incidents in a kind of mocking way. But there's nothing in the slightest funny about really what is now happening to Julian. And yet throughout the day, he's forever taking notes, trying to pass these notes to his barristers, yesterday, he stood up and made a wonderfully full-throated protest. Basically, the fact that Khaled al-Masri was not allowed by this judge to give evidence, and his voice wasn't even allowed. We had the charade of an Arabic interpreter trying to connect him up in Germany, as if Germany was on the moon. And this ridiculous situation went on for 3/4 of an hour. You know, was it contrived? I would say almost certainly. So finally, the interpreter was dismissed. We didn't hear al-Masri. Al-Masri was prevented by the judge anyway from appearing. So Julian stood up and protested this. And it was good to hear him, strong of voice, quite eloquent actually in his outburst. But this is an ordeal. This is a show trial of the worst kind. The due process has been replaced by a kind of due revenge. I felt yesterday, I felt almost a little bit optimistic that perhaps they think they've gone too far now. Perhaps this trashing of British justice in one of the oldest courts in the world was just taking it a little too far, because this judge, who has showed such personal animosity towards Julian, her facial expressions have been a kind of spectrum of dismissal and sneering towards him, was allowing some things to talk. When Julian spoke out, instead of, as she usually does, warn him that she would throw him out of the court, she let him speak and then simply told him to sit down. So this extreme, which this court represents, may have touched its limits. Where that goes from here, I don't know.
John, as a journalist and a filmmaker, do you feel that one of the reasons the press seems to be so failing in its duty to cover this might be because they know that they're not going to face backlash, because they know they're not going to basically go against the political narrative that's pushed by, powers that be? Or is there some other reason that you feel they're not covering it, despite the clear danger to the press that this case holds?
I'm starting to get a little weary of hearing how the impact of this trial on a free press. There is no free press. In my own country, Australia, 70%, where you are, 70% of the capital city press is owned by Rupert Murdoch. The rest are pretty much the same. In this country, Britain, this extraordinary trial, this landmark trial, this demonstrably political trial is being effectively ignored by the press, be it the BBC, the Guardian, as if it didn't happen. It reminds me of Harold Pinter's great speech when he accepted the Nobel Prize, that it simply didn't happen. It didn't matter. Therefore, it didn't exist. They're trying to make Julian into an unperson. Whether or not they succeed, I think depends on people like yourselves. Certainly some of the witness, the expert witness, especially Dan Ellsberg's and John Greutz's, the German journalist, and well, all of them actually. The defense is winning hands down just on the quality of its expert witnesses. I so appreciate the way everybody deals with these wretched prosecutor English representatives of the US government as they play their rather pathetic games to try and trick people into not telling the truth, in fact. But that hasn't happened. It's a capricious, it's a cruel occasion. I think we can't emphasize that enough, nor can we emphasize that in so many ways, Julian Assange is our collective conscience, in the same way that Dan Ellsberg was at a critical time in the prosecution of that endless war in Southeast Asia, which I reported. People like Dan, people like Julian, and a very few others are critical to our sense of decency, society's sense of decency. I'm frustrated by the fact that so many people don't really know what is happening in this courtroom. I'm not surprised by the way journalists regard it and misreport it and ignore it and even continue to defame Julian Assange.
It seems to me that the prosecution case was trying at one point to get away from the subject of Julian Assange being a journalist. They basically conceded that one. They're now acting that he is a journalist, but they're going for him under the Espionage Act, and they're saying that it affects journalists everywhere, and it could be used against anybody who carries out investigative journalism. What struck me, there was a point in your testimony which really, for me, was incredibly important. And that is that, of course, again, the prosecution is building up this argument about, the witnesses, the people that he supposedly put at risk. And you said, well, first of all, we've not actually had any evidence that he put people at risk, but we mustn't ignore the greater issue of what he exposed, the enormous war crimes that he exposed. And it seems to me that this is ultimately the essence of this case. We're talking about a journalist who has exposed war crimes on a massive scale, focusing on these narrow issues, should be seen for what it is, using those issues to basically conceal war crimes.
Well, I agree absolutely with that.
Yeah.
I think that the list of achievements is not known, not widely known. Even on Cablegate, which followed the revelation of war crimes in Afghanistan and Iraq, Cablegate showed that basically the British Army were making a mess of what they were doing in Afghanistan and were up to their own necks in criminal activities. It exposed what was happening in Sweden, that Sweden had been living a lie, pretending to be outside NATO and outside the American orbit for a long time. It exposed that Hillary Clinton had ordered diplomats to steal personal information, including DNA, fingerprints, iris scans, credit card information from diplomat, and tap the phones of UN officials. it exposed that Britain's endless Iraq inquiry was fixed to, quote, to protect US interests, and so on. That's just a few of them. There's so many others. This was journalism running on with such extraordinary power, and what made it different from other investigative journalism was that all of it was authentic. Having myself been, I suppose, an investigative journalist, though I must say I started out and the term investigative journalist wasn't known. That was what a journalist was meant to do. Then it became an investigative journalist. But it's 100% authentic. That's a very difficult standard. That's a high bar. How do you achieve that? Well, you only achieve that if you produce authentic evidence. That's often difficult. You can produce a series of facts that make up part of a jigsaw, but what WikiLeaks has done is produced all this authentic stuff. And it's done it including 800,000 files from Russia, which are seldom mentioned, all over the world. We'd be here all night and morning talking about the sheer enormity of what WikiLeaks has done. So this prosecution has been left with redaction as an issue. Redaction isn't an issue. As the Manning trial itself brought in, I think it was Brigadier General Carr, who had spent a year with a team investigating whether Manning's disclosures, basically the WikiLeaks disclosures, had led to anyone coming into harm's way. And he said there are no specific examples. In other words, no. And as Dan himself made the point in his own evidence, 15,000 files held back. It's the set in the context of what WikiLeaks revealed. The numbers, I think Dan, you may have referred or alluded to this in your evidence, the recent study by Brown University that 37 million people had been displaced since the war on terror began, and probably there've been 12 million deaths. I mean, that's what WikiLeaks was giving us true evidence of, made horrifically vivid by the collateral murder video, which of course the prosecution is desperate, as it tells every witness that comes on. Look, Assange is not charged with that. Well, they corrected immediately, and he's charged with the rules of engagement. And this is the most vivid example of the rules of engagement. Either these are the real rules of engagement or rules of engagement being flouted. Look, my having sat through courts last year, having sat through much of this one, this is a case that should have been thrown out long ago. It demeans the law. It demeans this court every time it convenes. Not the witnesses, they actually give it a dignity it doesn't deserve, but it should have been thrown out. I feel that I have no confidence that this judge will do anything but find that Assange should be extradited and that hope lies in the Court of Appeal, the High Court in Britain, where some real judiciary still reside, I understand. I've seen them in action. Occasionally, they can be very conservative, but occasionally, one or two of them will express their own belief in the law, that that's what they are there for. And I think that that's where hope lies. If that doesn't happen, of course, Julian goes to the United States and we'll never see him again.
Could I raise a question here of some of the people? I've been puzzled at the fact that the prosecutor is allowed, or does, one after another, ask one after another witness, or tell them rather, that Julian is only being charged with publishing, being charged with counts of having not redacted, having failed to redact the names of some informants. Now, that's manifestly untrue. He is making a false statement about his own indictment that he's working with, the charges. And that's been pointed out by Edward Fitzgerald time after time. And I noticed that he makes the claim, I now see before witnesses, before me and after me, and in my case. How is it that he can keep saying that, raising that clearly untrue characterization of the charges against Julian?
Well, the short answer to that, Dan, is that there's no judge to contradict him, and a judge surely would contradict him right at the beginning. So it's left to Edward Fitzgerald, as you say, to contradict him. But because the judge plays no part in this, in any kind of serious judicial role, that he's allowed to go on with it.
Well, then there's another point. A key when they emphasize these redactions of people who slipped through the redaction process, and evidently some did, the charge against him, as I read it, is purposefully revealing these names. Now, witness after witness has said very compellingly and in irrefutable detail that enormous effort was taken, more by Julian than by the press, The Guardian, for example, which was pressing him to release these on deadline, on time, when Julian was saying, I need more time to redact, and was applying a heavier program to get them. So nothing could be clearer at the end, so far, and even long before the testimony, and not from me, from the others, that he was not purposeful. He was the opposite. He purposefully was trying to keep these people from being revealed. So how they can even sustain that charge in the face of this evidence is not clear to me, and that's the heart of their accusations so far. And by the way, the prosecutor can come and give me, how can you say they were not in danger? Look at these names that were mentioned. Well, he's listing at, you may have noticed it's several minutes length, I had to sit there, but he goes through all these names of people who might reasonably have been thought to be in danger and might reasonably have worried about themselves, despite the fact that one would say that the test of the danger in the end is whether anyone was harmed. And rather amazingly, to my own surprise, there is no evidence, direct evidence, that anyone was harmed. And then, Alexander, as you put it as you brought up here in the context here, we're talking about several hundred people who understandably felt some anxiety that was imposed on them by the failure of the US government to lift a finger to keep their names from being published. When they were offered the chance to redact, to tell the names, they knew, as they said, they had a list, they had 120 people in defense, others in state, trying to find out and finding out whose names were used. They were asked to give those names so they could be redacted. That's the opposite of purposefully here. They refused to do that. I can guess at some reasons, none of which do them very much credit, but in any case, from their point of view, they were purposefully, willfully, I think the word is willfully here, exposing those people to what they thought was danger, or what the people might have thought was danger, for other purposes, rather than take their names out of play. Now, all of this, as Alexander pointed out, in the context of a war of aggression, a crime against the peace, participated in by Britain and others, in which millions of people were being harmed, not just put in danger, but were being harmed. You know, I haven't seen anyone notice on this absurd thing of the glass behind which Julian is being held, that there is a precedent for this. I haven't heard the word Eichmann. After all, there was a movie about him, The Man in the Glass Box. And that's genuine. Now, who is Eichmann? A man who organized the extermination of millions of innocent people. Well, we're talking about a war that Julian was manifestly trying to shorten, as well as to expose and to change the practices in it, but above all, to shorten a war in which the US has killed more innocent people than were killed at Auschwitz. And I am giving the figure of 1.2 million people killed at Auschwitz alone. And we have brought about the wrongful death of more than that. So the irony of this situation, it's as if someone who exposed the Holocaust is the one person to be sitting in a glass cage. The truth is, in our country, the only person who has been held accountable and went to prison for, in connection with, a program of torture which violated international law, domestic law, the Constitution, blatantly, this program of torture. The only person punished for that is John Kiriakou, who exposed inadvertently, by the way, the name inadvertently because he didn't think the person was still a clandestine agent, and having had retired, and it turned out he was still. But John went to prison for exposing that name of a torturer. So I say to you, yes, your point is well taken. The press in my country has been, I started out by saying, derelict in addressing the secrecy system. I'll even give, if I may, to a couple of the journalists here, a guess and let them see as to why they haven't addressed the whole abusive nature of the secrecy system entirely as a system of censorship. And that is that they live very well with it. Secrecy allows them to have scoops, exclusive leaks from an official who daily, hourly almost, will reveal secret information that serves their own reputation or their agency or the president's wishes. And they give it exclusively to one journalist. If it was open in a press conference, everybody would have it. But with it being secret and this being a regular violation of the secrecy rules, I get my scoop today, someone else gets it next week, and if I'm a good boy, I'll get another one eventually. So in this area, we don't have democracy. We don't have a republic. Surely Julian would be seen as having violated the British Official Secrets Act, open and shut here, especially after 1989 when they said no public interest defense after this. But what's the difference here? Britain is a monarchy, they're not an active monarchy, but they are an empire. They have nostalgia of empire. They aren't really anymore. But their laws at the time of our revolution or war of independence was a monarchy that we were trying to break free from. To have the lack of an independent press makes the head of state a monarch, a king, a dictator, which in theory we don't want, but it's what we have, especially in the area of military policy and defense policy.
I think that's absolutely right, Dan. I often feel, as one who, if you like, grew up in the British press, but spent a long time in other countries, especially the United States, as a reporter, that there was a mythical free press, and like many myths, it was partly true. And I think when you were prosecuted in the 1970s, in the United States, I put your prosecution and the church committee hearings as really the end of, if you like, open democracy. Open in a way that the influences of the post-war period, the 60s and particularly the 70s, was the beginning of the end. Because from the moment that Reagan came to power and Thatcher came to power over here, things began to change. Began to change in so many ways. An economic war on people, a concentration of the media, all those newspapers across the United States, like all those radio stations before television came across, that was a free press. Some of them weren't very good, but often they were. They were local. Some of them were campaigning newspapers. That existed in Britain. It certainly existed in Australia. So the whole notion of being a journalist, of being part of, if you like, the fourth estate, even at that level, was a legitimate one. It may not have been wholly true, but there was always a chance. In other words, in the so-called mainstream media, as we keep calling it, such a misnomer, there were spaces. I mean, I occupied, in this country, space in a national newspaper and on television. There were spaces where journalism that disagreed, if you like, or went against the grain of the newspaper, even against the grain of the advertising, was tolerated. That was part of the times. That was certainly reflected in the great work done on the BBC here in the 60s and 70s. All that's gone. Those spaces have closed. They've closed down. There's still perhaps one or two here and there, but we have now, and what we're doing today is a form of it, a form of samizdat. I mean, we're reduced to a kind of dissident journalism. I mean, this is the best kind of dissident journalism. This is dissident journalism, and the other work that Joe does on Consortium, and Bob Parry before him, then that's wonderful, because it's exploiting this technological treasure of the internet. But the old idea of the press, television that followed it, and radio has gone, I believe, as homes to free journalists. There are a number of very fine journalists now, but they're all on the net. Most people don't know about them. We know about them, we look for them. But I'm constantly being asked at universities or public meetings when we're still allowed to have those things, where do we look? And I'm really always surprised that they don't know about certain websites where there is free journalism, but that's where it's gone now. But the old media still has huge power, and power to damage and destroy. And it's, if you look at the almost decade-long campaign of vilification against Julian, that's one of the most shaming periods in the history of, if you like, the old press, the liberal press, the Guardian, the New York Times, the Washington Post. They've all been in on it. It was so was such a relief to hear John Goitz's evidence. He was someone from the liberal press in Germany, Der Spiegel. He's now with German public radio, telling us the truth, speaking as journalists, as I remember, the few anyway, in the 70s and perhaps later, speaking, telling the truth. I think the world has changed, and perhaps we need a fifth estate now, where journalism is recognized as having changed completely, and that we bring in all kinds of people. This futile debate over whether Julian's a journalist or not, I mean, it was derogatory, most of it, but some people actually believed it. That should be in the past now, and we should welcome people who can provide the extraordinary public service that WikiLeaks has, and that recognition.
There was just something I wanted to say, which relates to what you were saying, John, about the way the case is conducted, because this is incredibly upsetting, because of course what is happening is that Julian Assange is being punished. He is being punished in the most cruel way. He's not been convicted of anything. Some of this is, frankly, I would call it torture. I mean, it's torturous anyway. It is obviously calculated and planned the way you've described it. Now, we have, of course, various provisions in our law in England that are supposed to protect defendants in that kind of situation. And these laws come from international laws. We are party to the European Convention of Human Rights, which outlaws torture, which makes provisions for fair trials, which talks about freedom of speech and the ability to pass information. We are also parties to the various, international conventions on torture. We've already had the United Nations rapporteur saying that Julian Assange is a victim of torture, to which the British government has been complicit. Now, if you've been living in Britain over the last few weeks, you will know that there's been this huge hubbub about the British government changing international law, passing a law that's going to go against international law over this issue in Ireland. And I'm not in any way disputing the importance of that, but they're all saying that this is somehow unprecedented, this is remarkable, Britain doesn't violate international law. We are violating international law now in the Old Bailey, in one of our courtrooms, right at the very centre of our legal system. And of course, you cannot have a free press, a kind of free press, in any situation where law doesn't function. And it seems to me that these two things go together. So both Julian Assange, this case is so important at so many levels. Firstly, because it is a law about freedom of press. It's a law that exposes war crimes. But it is also fundamentally a case about the law itself and about human rights.
Well, can I comment on it's very good, Alexander, I totally agree, but I want to draw attention to a difference in the legal situation in Britain and America. Well, there is not a difference in the legal issues, as you pointed out, relating to torture. That the US is subject to international law and domestic law and the Constitution that makes it totally illegal, criminal, actually. What Chelsea Manning revealed in part in Iraq, and I helped introduced Julian in London when he delivered the Iraq files to the press. And one of the things she revealed there was that there were hundreds of cases and she had even been in one herself, that's what drew her attention, hundreds of cases in which Americans protested giving Iraqi captives to Iraqi forces in the knowledge they would be tortured. And they were in every case told, don't pursue this any further, don't investigate. That was an illegal order because the international conventions on this make it clear that when a reasonable allegation of torture must be investigated, must be prosecuted if it's found to be valid. It was illegal to tell them not to pursue it or to turn them over as illegal and criminal as if we had tortured them directly ourselves. And nevertheless, President Obama effectively decriminalized torture when he refused to prosecute any of the people who had manifestly taken part in it as a policy. In effect, he was decriminalizing torture from a practical point of view. But on another issue, though, there is a difference, I'm told, and that is this. One of the prosecution people, witnesses I saw in the records, actually said at one point, there is a necessity defense. It's a defense in the US on these grounds that what you did was justified to avoid a greater evil. It's sometimes called a choice of evils defense or necessity or a public interest defense, that it was public. He said there is it. That was flatly false by the prosecution. That does not exist in the case of the Espionage Act. Now, I was under the understanding that, I was aware that after the Clive Ponting case, in which the jury had quite rightly taken account of a public interest offense, that it was false for Thatcher's government to say that the battleship General Belgrano had been attacked and destroyed, sunk in the Falklands or the war, the Malvinas, because it was approaching the British ships and endangering them, when in fact it was moving away from the British ships. Okay, when he revealed that, put on trial, the judge virtually gave a directed verdict to find him guilty, and the jury didn't agree, quite rightly. He absolutely did the right thing. Whereupon, as you know, Britain, the Parliament quickly passed an amendment to the Official Secrets Act that there was no public interest defense. That would be like the US. However, as you said, they are in principle subject to the European Convention on Human Rights, which does allow for a necessity defense. And if Britain observed that in a prosecution, it's not coming up in this proceedings, but if they observed that, he would have the right to explain his motives and what the impact was and whether these people had been in danger or not, as opposed to the other people we were putting in danger by keeping the process secret. Okay. In America, he would not have that. So it's a question of extraditing him to a country where he would not have the protection of the European Convention on Human Rights. The US does not feel bound by that. It seems to me that would be a very strong case against extradition. Am I wrong?
But there was a case a couple of years ago, which is the Catherine Gunn case, which was a whistleblower who exposed information that in fact came out of the US, which related to pressure that was being exerted by the US on UN Security Council members to support the resolution that would allow the US and Britain to attack Iraq. So she exposed it. And as I remember, she defended it ultimately on the basis that she was exposing a violation of international law and that it was in fact a necessity defense. She was actually making the necessity defense. And in effect, the British government decided literally at the door of the court that they weren't going to test it. Now, in other words, they pulled back. They actually dropped the charge literally as she was facing the judge on the first day.
If I may say, I agree with you. I was very close to the gun case because when I saw in the Observer, I guess it was on a Sunday, I saw it thanks to the magic of digital communication here right away, that someone had leaked an operational cable about the NSA, National Security Agency, to its counterpart, GCHQ, in Britain. And I saw this is of a level of secrecy that even I, with 12 clearances higher than top secret, I had a special compartmented clearance for the results of communications intelligence, but not a clearance for the process of who is targeted and by whom and where and for what purpose and so forth. So someone was leaking something of great secrecy on the one hand, exposing themselves unmistakably to prosecution, and on the other hand, of great significance, because as Catherine Gunn said, when she revealed herself, her purpose was to expose illegal methods to gain entry to an illegal war, a criminal war. Now, she was able to say that to the press and in court. I'll point out, first of all, she could not have said that in an American court, because if she were on trial here, the judge would do, if I tried to say, if I was in her position, and I was, with lesser material, mine was only top secret. Chelsea Manning's, Julian Assange was only secret below that. Hers was at a much higher level. But if I had said, this was my purpose, the prosecution would say, as they did in my case, irrelevant, objection. And the judge upheld him totally. My lawyer eventually, having tried to get it through in different wording, said, Your Honor, I've never heard of a case in which the defendant was not able to tell the jury why he, or in her case, she, did what she did. And the judge said, well, you're hearing one now. Well, every defendant on the Espionage Act of a whistleblower, and there have been a dozen or more than a dozen now, so has had that same problem. So she wouldn't have been able to say, I was revealing illegal material and so on. She couldn't even say that. But second, rather than give the British government, the British draw too much benefit of the doubt here as to why they dropped this. They dropped it immediately after they learned from the witness list to be called by the defense. The name was, I'm pretty sure, Elizabeth Wilkinson, who was the highest legal officer who had resigned in protest over going into an aggressive war, a war of aggression, without a second resolution from the Security Council authorizing it. And rather than hear that witness testify in court that the war was illegal, they quickly backed off. But I repeat, that issue would not have arisen in an American court at that point. She wouldn't have gotten off on that point. So to extradite her to this is like what happened, by the way, to Mordecai Vanunu, kidnapped to an Israeli court, a military commission in secret for revealing the nuclear weapons being held by Israel, including possibly H-bombs, kidnapped and prosecuted. Well, strictly speaking, Eichmann was kidnapped and faced it. But he was unquestionably said, I will leap into my grave happy that I killed 6 million Jews. And here we have a man being, in effect, kidnapped with the help of the British government to face charges that he was trying to stop a process of an illegal war in which millions were being made, were killed, and 37 million in the end in the Middle East made refugees. So it is a mockery. And I agree, the defense lawyers here, I'm sure, are aware of all this, I'm sure. But as John said, this trial should have been pushed out, or this extradition should have been pushed out long ago.
Small comment about Julian being in that glass cage. In an American court, the most common street criminal, thug, is brought in, and he gets to, maybe for the first time in his life, to wear a suit and tie. And he sits right there at the table with his defense attorneys, and he can confer anytime he wants with them. And yet Julian Assange is put in this glass cage. I just find that one of the more remarkable things about this entire case. We've been over an hour now, unless Alexander or Elizabeth have another question. Do you, Alexander?
Not a question, but just a point, Joe,
Okay.
on what you just said, which is that in fact there is case law, substantial case law, brought up by the defense earlier in these proceedings about the glass cage. The European Court of Human Rights has repeatedly said putting prisoners in a glass cage in that way violates human rights. It's contrary to Article 6 And the country that does it most famously and notoriously is Russia. And there's been repeated judgments about the Russians doing it. And here we are, we're doing it in the Central Criminal Court, and beforehand we did it in the Westminster Magistrates Court. So she's just paid no attention to any of that at all.
Alexander, I would like to ask a question about the issue of dual criminality. Obviously, it has to be a crime in Britain and in the United States.
Yeah.
So the issue of a journalist, an unauthorized possession and dissemination of defense material, is that a crime in both Britain under the Official Secrets Act and the Espionage Act? What I mean is it has to be a crime in both the United States.
Oh, yeah, absolutely.
Britain, correct.
That is a fundamental
why,
principle of extradition. If it's not recognised as a crime here, what he has been charged with, then it is not a crime that the British authorities can extradite him on.
Sorry, John or Daniel, do you have anything to weigh in on that? Is the language is pretty much the same in the Official Secret Act and the Espionage Act when it comes to unauthorized possession by a journalist in this case?
As applied, the Espionage Act was never intended, allegedly, to be an Official Secrets Act, and was not designed to be one, and it can't constitutionally serve one, but it as an Official Secrets Act like Britain. But it has been used as if it were an Official Secrets Act with respect to officials and former officials, essentially sources. I would say, and legal scholars have said, that alone is unconstitutional, but it is a more restrained use and it's passed muster. Up until now, they have not tried to use it as an Official Secrets Act like Britain's against a journalist or a publisher, because Britain doesn't have an amendment that says Congress shall enact no act abridging freedom of the press. That was an American invention, as far as I know. And it was one of the things that distinguished us from the British Empire, supposedly. Well, it hasn't with respect to sources, but it has up till now. Without that First Amendment, we would have been prosecuting, that is, the government would have been prosecuting journalists right and left for the last half century. So it has worked to that extent. If this case goes ahead, and then this administration, with the help of journalists who continue to say, oh, it still isn't being used against the journalist, we don't have to attack it so much constitutionally because it still isn't aimed at us. That is of extreme short-sightedness. It's a kind of denial by the press that it isn't going to be used against us. And if it is then tried, we will have in full the British Official Secrets Act. The next step, by the way, would be applying it to people who simply retain and hold, like a reader of the newspaper. And actually, there has been a case not unlike that. The AIPAC case involved two what amounted to Israeli lobbyists, but in any case, it hasn't been officially held to be. But they weren't journalists, and they weren't officials. And the case was, the judge looked at that and narrowed the interpretation of the wording beyond the clear meaning of the words to say, no, you can only go against them with specific intent to harm the United States, which is not the language of the act. But he did that to preserve the act from constitutional challenge. And actually, the Obama administration dropped that prosecution. So this would be the first. It would extend to people who were not journalists and not officials, who simply possessed the information and obtained it and retained it, like readers of the newspaper.
Yeah, final thought. Well, I think this is, we're rightly arguing about whether the law says something or not, or whether there's proper sanction by the law or not. But I think we're in an era of politics, of political oppression. And if you go back to when the Espionage Act was quite hurriedly enacted by Congress in 1917, President Wilson had no doubt what it was meant to do. He described it as the firm hand of stern repression. I like the way politicians actually spoke the truth in those days. But as I understand it, it was used against those Americans who didn't like the idea of the United States joining Europe in at the end of the First World War, and there's a great deal of dissent about it. And dealing with anti-war activists, dealing with people who spoke out, dealing with conscientious objectors, as I understand it, was the aim of the Espionage Act. And in its 103-year history, it's never been used against a journalist. And this is the first time, and it was utterly bizarre to listen to the Claire Dobbins, the number 2 of the prosecution team in court yesterday, trying somehow to prove that the Espionage Act was actually designed to stop journalists threatening the state, and that that it was used against Julian Assange only showed that there'd been an enormous prior restraint by governments not to use it against journalists, and this was perfectly normal that they were using it. That's the kind of level of legal argument. All this adds up to is lawlessness. There is a lawlessness now in those countries that regard themselves, that used to regard themselves as centers of international law. Of course, they weren't. They were centers of international power. But, and Britain especially saw itself as the as a place where British justice would always prevail. Perhaps that was never true, but even that myth, like the myth I mentioned of journalism, has gone. This is an utterly lawless prosecution. There is no new due process. Anybody with any sense of the law, let alone decency, seeing it every day after day, should be shocked. But I think perhaps it was you, Alexander, who mentioned it, that the laws can be just changed in a cavalier sense now. The Brexit law is changed. As far as Julian is concerned, the UN, all the UN conventions that were expressed, and the full weight of UN authority was expressed by the Working Party that condemned his incarceration, and more recently by Niels Melzer, the UN reporter on torture, is dismissed out of hand. So that a foreign secretary can talk openly about Julian having been charged. Never charged, of course, but that's the media myth which he can now promote. So the short of it is there is a lawlessness, and we have to understand that now. And perhaps its epicenter, as far as we're concerned, is now in Court 10 in the Old Bailey.
Let's see how far we've come. John, you mentioned the Espionage Act was enacted to put down and stop the opposition to the entry into the First World War of the United States. And many journalists under the Sedition Act, part of it, were imprisoned, or Eugene Debs was. And part of that opposition to the U.S. going to war in the First World War was the words of George Washington in his farewell address, that the U.S. should not become entangled in the European affairs. By the way, that farewell address was given exactly on this date, September 19th in 1796. And I want to just draw attention to what Daniel said in his testimony. Another way to show how far the U.S. has fallen in that the documents that Chelsea Manning leaked, some of them were field reports that Dan said he wrote himself when he was at the embassy in Saigon, and that he would never have written into their details of torture or assassination program like the Phoenix program. That would have been highly held secret to the highest levels of government. And yet here, the U.S. doesn't care that thousands of people with security clearance could read those. I just wonder if you would comment briefly on that, Dan. When you spoke about the field reports that you wrote, that Chelsea Manning's field reports now mention torture in them, whereas when you were in Vietnam, that would never have happened. It would have been a much higher level.
A slightly different point. I've said I would have been astonished to read them in the Pentagon before I went to such things at that level. Certainly, I did not mean to imply, which you suggested a bit here, that I was aware of torture in Vietnam, that I would not have reported at the secret level.
Oh, no, I'm not saying that at all.
No, in Vietnam, I wouldn't have just reported it, I would have opposed it to the limit. And people who did that, like Lieutenant Colonel Anthony Herbert and another Colonel Hackworth, who did report, it was essentially run out of the service, but they were obeying their oath, not to obey illegal orders. And that's what I would have recognized at the time. Though there was torture going on, but it wasn't made known to me. Actually, my co-defendant, Anthony Russo, who had been interviewing prisoners, became aware of the torture. And when he wrote about that in a report to the Rand Corporation, it was, I am sure, a factor in his being fired by the Rand Corporation. Later, he joined me as a co-defendant putting out the Pentagon Papers. So what I am saying, though, is that given that it was happening, why didn't I see it? And the answer is you wouldn't put that in a secret level at that point. Now it's put out to Chelsea Manning was what rank? A corporal or a sergeant? Not above a sergeant. 100,000 corporals were now made available of the fact that we were handing people over for torture, a clear violation of international law and American domestic law. And no, they weren't worried about it. It's become routine. And why not? Because not one single person has been prosecuted either by military or civilian court for having indulged in this. And it's not just an ordinary crime like, well, let's say jaywalking or trafficking or something, or even embezzlement or something like that. We're talking about a law that's regarded as I understand now, as jus cogens, one of a small category of acts so atrocious that no legislation can enable them. It can't be made legal. It not only is illegal, it can't be made legal. And yet it's being done in a way that, as I say, more than 100,000 people were made aware of it. It was being reported by people who didn't want to do it, hundreds. And yet inside, and by the way, that reached to President Obama. Unlike the Pentagon Papers, which were all 3 years old by the time they came out and did not apply to the then current administration, Chelsea Manning and Julian Assange were putting out stuff that did extend into the Obama administration. And I don't think it was a coincidence that they went after them as hard as they did, because it was pointing a finger of criminality at the president, that this was a clear-cut policy. And if President Obama or Trump or before him Bush had been brought before the International Criminal Court, of which they refused to acknowledge the jurisdiction, I have no doubt they would have been convicted of a number of things. Crime against the peace, as I've said, but also war crimes, including torture or the collateral murder, the atrocities that were going on. One last thing, one of the things that Chelsea revealed, and Julian has revealed, in other words, is that the US had refused to prosecute, failed to prosecute Americans who were clearly guilty, in the facts of atrocities in Iraq, meaning that the Iraqi parliament, when that came out from WikiLeaks, could not accept the presence of American troops with the normal status of forces agreement, which would make them immune from Iraqi prosecution. With no Iraqi prosecution, no prosecution, because what Julian revealed was that the Americans were, contrary to their obligations under law, refusing to prosecute these people. And that meant that they couldn't, that Obama had to obey the deadline that George Bush had set and that he had set for getting troops out of Iraq. He wanted to keep them in longer, and he couldn't because of these revelations. So I thought of that as one of the significant consequences.
The word you used in your testimony was normalized, that torture and assassination programs have become normalized, that they would be in such a low-level document that somebody like Chelsea Manning could have. And it's something I wrote about, comparing the My Lai massacre to the collateral murder video. In the My Lai massacre, the whistleblower was actually listened to by Congress, and it created an investigation. And there was, of course, Calley, who was convicted. In the collateral murder, the whistleblower went to jail, Chelsea Manning. In My Lai, the journalist, Cy Hirsch, got a job at the New York Times, got a Pulitzer, got a job at New York Times. In the collateral murder, the journalist is in jail right now and in an extradition hearing. So I just wanted to point out how far the U.S. has fallen in these regards.